So we're going to talk today about original jurisdiction of the United States Supreme Court. There still are some questions relating to this, so I want to go over it again with everybody so we can understand the situation, and certainly the litigation that we're bringing forward here. So we all can agree that the Constitution of the United States of America is the overarching requirements that every state must follow, that our government must follow it. The purpose of our Constitution was to establish rights and limit powers. People have rights, government has powers. It's a very, very important thing. States and government does not have rights, they have powers. So, for instance, earlier today, we heard Secretary Noem talking about the individual that shot the Miss Good in Minneapolis. That she was saying that this officer feared for his life, therefore he had the right to be able to, to do what he did, and that would be true because that's the right to self-defense, and everybody has the right to self-defense. But the problem is that government has powers, and the way that government exercises its powers is through its agents. The apparatus is the agents. Therefore, when a person is acting in official capacity, they have powers, but they don't have rights. You see, and their powers are limited by the law. So again, the Constitution is designed to establish rights, limit powers. People have rights and government has powers, but those powers are specifically limited in order to protect the individual liberties of the people. So in some cases, federal powers are limited. In other cases, state powers are limited. In more cases, both powers are limited, but the powers are actually limited in order to preserve the individual liberties of the people, which is the purpose of our Constitution. So my point here is that if you want to know how to change the Constitution and change the terms of the contract, the constitutional contract by and between the people and our government, you would go to the special amending procedure of Article 5, and that tells you the way in which you would change the Constitution for the United States of America. Can't be done any other way. So a lot of people talk about multiple constitutions, Constitution of 1871 and these other ones, and what I have to say to that is that the Constitution, the original one, the 1787 Constitution that was ratified by the people, that was the original contract. In order to change the terms of that contract, government can't breach the first contract to create a second contract without breaching both, because you can't create a new contract by the breach of a contract. That would, in contract law, if the way in which the contract is formed is illegal, then the contract formed, of course, becomes illegal. So I'm going off of the 1787 contract, right? That Constitution, because the people of the United States have never ratified a different contract. So we're not going to talk about any other constitutions. We're going to talk about the 1787 Constitution, and that's it. But so again, what the point of the Constitution was to provide a limit of power. So the Article 3. The first three articles are establishing the three branches of government. So Article 1, of course, is the legislative branch, and that's the obligations that the legislative branch has codified in the Constitution. Second branch is the executive branch. Third branch is the judicial branch. So when we talk about original jurisdiction, what you guys need to understand here is that in order for a court to render a legally binding decision, it must have two things. It must have subject matter jurisdiction, and it must have personal jurisdiction. Subject matter jurisdiction is the right to oversee the type of case that is brought before it. So, for instance, in the case of a death, you wouldn't bring that case to a small claims court because they wouldn't have subject matter jurisdiction to oversee the disposition of the deceased assets. You would bring that to a probate court because a probate court would have subject matter jurisdiction to deal with that particular matter. Now, the second thing that the court must have is personal jurisdiction. Okay. And personal jurisdiction is the right to oversee the parties involved in the dispute. Okay. So original jurisdiction is a reference to the court that is acting first, the original court. No other court in the country can act before the court that has original jurisdiction, because that's the court to act first, the original court of jurisdiction. So, so Article 3 it actually identifies two different jurisdictions of the United States Supreme Court. And the first is original, the second is appellate. We're all very, very familiar with the court's appellate jurisdiction because we exercise that every day, right? We go to the court and we believe that it's a court of last resort, so we will file an appeal to that court asking it to review our case. And we get into discretionary issues there and other things, but original jurisdiction is also in the Constitution. And what it says specifically, you guys go out and read it, confirm this for yourself, right? It's never been changed, it's never been altered, and the law is very clear. It says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So again, it says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So what it's saying there is that if a state is a party in a cause, then the state does not have personal jurisdiction to oversee that cause, because no man can be judge of his own case. The state cannot be judge in the state's own case. So if the state creates a law and says that you have violated that law and brings an accusation of having violated that law through one of its agents, being a law enforcement officer, a prosecuting attorney, CPS, right? If the state brings an accusation of you violating the law, then that would mean that the state no longer has jurisdiction to oversee the disposition of that dispute, because the Constitution of the United States of America has removed jurisdiction and assigned original jurisdiction to the United States Supreme Court. The other thing you need to understand is that the Constitution is not referring to a state Supreme Court, because the state Supreme Courts was not what was created by Article 3. Article 3 created the Supreme Court of the United States. So when it says Supreme Court, it's referring to the United States Supreme Court. Now, what does this mean, right? Well, so personal jurisdiction, the right to oversee the parties involved in the dispute. According to the Constitution, anytime that a state is a party in a cause, personal jurisdiction, the right to oversee the parties involved in the dispute, is constitutionally assigned to the United States Supreme Court. That's the court that acts first, right? No other court in the country has the authority to be able to oversee that particular case, because the Constitution has created the obligation. Now, there's two very, very important things to remember here, all right? One is the right of discretion, because we all say, well, the Supreme Court has the right to use their discretion to decide which cases they can hear or not hear. But what you need to remember is that discretion was created by the 1925 Judicial Reform Act. So this was an act of Congress. Prior to 1925, the Supreme Court was not a court of discretion. But in 1925, the United States Congress said, okay, the Supreme Court of the United States and all of the state Supreme Courts are all now courts of discretion, meaning that they get to pick and choose which cases they want to hear or not hear. But acts of Congress must also comply with the Constitution, because if they don't, then they themselves are unconstitutional. So my point is that the Supreme Court, the state Supreme Courts, the United States Supreme Court, they can be a court of discretion so long as a state is not named a party. If a state is named a party, then an obligation exists, right? The law exists obligating the court to do it because there's a duty. And the duty was established by law. Therefore, you can't use discretion to violate the law. This is called an abuse of discretion. So if the state is named a party, then the Supreme Court does not have the authority, even under an act of Congress, to say, I'm not going to hear it. They can't use discretion. They could in other cases, but not if the state is named a party, because the duty is assigned to the Supreme Court to oversee it. The other thing that's important to remember is delegation, right? So if the Supreme Court says, well, we are delegating original jurisdiction to the United States District Court, well, what that would be is that would be an amendment to the Constitution, right? That would be a change to the obligation, because the Constitution assigned this obligation to the Supreme Court of the United States, said that you must oversee any case in which a state is a party. You must be the trial court, the original court. So, and you cannot delegate an obligation, because again, that would be an amendment to the Constitution. That would be changing the terms of the contract. And that must be done by an authentic and explicit act of the people in accordance with the special amending procedure of Article 5. So the Supreme Court does not have the authority to be able to delegate the obligation or delegate the duty, because the duty was created by the Constitution. That would be an unlawful amendment. So they can't tell you, well, you have to go to the United States District Court, that they have original jurisdiction. But the other thing is that just like I'm hitting these three branches of government, I'm telling these three branches of government that, hey, there's a codified obligation, there's a separation of powers that exists, and you can't exceed the limitations of power the Constitutions provide. But right, just like I'm saying that, you guys also have to recognize that you need to follow the law just as much as the Supreme Court has to follow the law. So every one of you, needs to employ what's known as preemption. This is the same thing I'm telling the judges that they have to do. Because when a judge swears an oath to the United States Constitution and the state constitution, anytime that there's a conflict, his duty is to determine which law do I follow, right? Do I follow the state law, or do I follow the Constitution for the United States of America? That's a process that's known as preemption. And just like judges need to employ preemption, you guys have to employ preemption as well. So when you're trying to determine, where do I submit my paperwork? What is the court that has jurisdiction? You need to remember, what is the supreme law? What is the law that you have to follow? And that would be the Constitution of the United States of America. Just as much as the judges have to follow the Constitution of the United States of America, we do too. So when the Constitution of the United States of America tells you in Article 3 that the Supreme Court of the United States has original jurisdiction, I know that it sounds crazy, right? It sounds nuts that we would go to the highest court for original jurisdiction, that we would go to them first and not last, but that's what the law states. That's what the law requires. So if the Constitution obligates them to oversee the disposition of a dispute anytime the state is a party and to act as the court first, then you guys need to recognize that too. And when you go to, for instance, Title 28, subsection 1343, which is the jurisdictional code under the judicial code that assigns the United States District Court as the court of original jurisdiction in any matter relating to civil rights and elective franchises. Well, you have to understand that would be an unconstitutional law. Because if they say that the state is a party, right, and you come forward as the state as a party, but then you rely upon a United States code that tells you to go to the incorrect court, well, you just broke the Constitution in your submission, right? You didn't follow the highest law. You didn't do what the Constitution required you to do, and so it's no wonder that you're going to get dismissed in your case because you didn't go to the right court. And just like if someone were to say to me, put a gun to my head and say, go rob this person, and I go rob this person, the gun is a bad example. If my boss tells me to go and rob someone and I say, okay, I'm going to do what you tell me to do and I'm going to go rob this person, I have no right to that criminal act, right? I have no right to claim immunity or claim that doesn't apply, because if I obey an unlawful order or I listen to someone and I take bad advice that tells me to break the law, I'm not immune from that criminal conduct. Ignorance of the law is no justification for having broken the law. So the point here is that when the Constitution says one thing, we need to follow it. Even if the United States Code says something different, even if the state statute says something different, we each have to employ preemption, and we have to decide which is the correct law to follow. And all of you need to make sure that you're following the Constitution and what it tells you to do, not what an inferior law tells you to do or an inferior statute tells you to do. So again, the Constitution identifies two jurisdictions. First is original jurisdiction, which means that they're the court to go first, the original court. No other court in the country can act before the court of original jurisdiction. So anytime that a state is a party in a cause, the Supreme Court of the United States has original jurisdiction. The Constitution then says in all other matters of equity and law, the court has appellate jurisdiction. And again, we're all very, very familiar with appellate jurisdiction of the United States Supreme Court. Because we exercise it every day. Now, I had someone come in just yesterday and started talking to me about the writ of certiorari, right? Why am I not submitting a writ of certiorari to the court? Well, you guys, a writ of certiorari is a request to review a lower court's decision, right? And I also found out last night that Dave Jose is now teaching this when this is what I've been teaching for, for 6 years, trying to get you guys to understand. And it's funny that, that he attacks me for 2 years and then now goes behind my back and starts taking the information and giving it to all of you as though it's his original, but it's not. And that's okay, right? Because the information is being spread. But at the end of the day, right, that a writ of certiorari is a request to review a lower court's decision. Attorneys and the system wants you to submit a writ of certiorari to the Supreme Court, because when you do, what you're saying is that there is a judgment that's in place and I'm asking this court for appellate jurisdiction. I'm invoking appellate jurisdiction. And under that jurisdiction, the court does have discretion. They can pick and choose which cases they want to hear or not hear, right? Because the law has permitted them to do it. So when you submit a writ of certiorari, all that you're doing is validating the judgment. You're saying that the judgment's valid, but there's irregularities within the adjudication process that either mitigates or eliminates the liability that's associated with the judgment. You're validating it, right? Because it looks at the end. So when you submit a writ of certiorari, you're invoking appellate jurisdiction, not original jurisdiction. And so this is the reason why I had to figure out a way to bypass the appellate jurisdiction and come in with original jurisdiction. Because in 1925, the same year that the Judicial Reform Act allowed for the Supreme Court to become a court of discretion, they also came out and said that the Supreme Court, the only way that you can petition them is with a writ of certiorari, right? So the United States Congress, they came out and said, okay, the only way that you can petition the Supreme Court is through this writ of certiorari. And what they did was they technically foreclosed upon our ability to be able to invoke original jurisdiction, right? Because if the only way that you can petition the Supreme Court is through a request to review a lower court's decision, then they made it so that you can never invoke original jurisdiction, because the only way you can petition that court is through an appeal, right? And so the Congress knew this, right? 1925, they knew this. There's a number of different indicators as to why they knew this, but nonetheless, they knew this. And they were trying to make it so that you guys were not going to be able to invoke original jurisdiction to the United States Supreme Court. So we had to find another way to do it. And the way that we chose to do it is an appeal, right? Or a writ of certiorari is an appeal. It looks at the end, right? It is a procedural or a claims processing relief. So, you're saying that there's irregularities and you're looking at the end and you're trying to remove the judgment through issues associated with the adjudication process. At the same time that you're submitting an appeal, you can also submit what's called a judicial relief, right? They're two different things. A claims processing relief is the end, judicial relief is the beginning. A judicial relief, what you're saying is that you're going to a judge and you're saying the state participated in the deprivation of a fundamental right without lawful authority, right, under color of law. And you're saying that the beginning was flawed because they abridged a fundamental right, and therefore nothing after it is valid. You're asking the judge to restore the original liberties that were taken from you by the state without lawful authority to do so under color of law. So this is done through writs, right? The writ of habeas corpus in particular is a request to restore liberties that were taken, fundamental liberties that were taken from you without lawful authority. It looks at the detainment, right, or the removal of the fundamental right. So the reason why we had to go that direction was because if we came in with the writ of certiorari, right, and we said, okay, well, we're asking you to review this lower court's decision, then of course they would have discretion. They would kick us out, and they would never hear it, because that's the play that the Supreme Court has, right? They don't want to hear big cases because they don't want to have major impact to their operations. So we had to find another way to do it, and we did it through the judicial relief, through habeas corpus. Because again, if the issue that we're bringing forward, right, not the question, but the issue, if the issue that we're bringing forward is that there's 700,000 people that are currently in prison here in America illegally and unconstitutionally because the states participated in a deprivation of a fundamental right through alleged color of law, right, a supposed authority, Well, that would be at the beginning. That would be the moment that the person was arrested and held to answer, because the Constitution, Clause 1 of Amendment 5, says that no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury. So the breach of fundamental right occurred at the point of arrest, when you were held to answer for the offense without the proper charging instrument in place. So that's the issue, right? The question is, of course, as a lot of you probably already know, the question that we have is, can a state be both accuser and judge in the same cause? And the answer there is also no, right? It's very, very simple, direct conflict of interest. But if the breach of constitutional obligation occurred at the moment that you were arrested and held to answer, then what we're doing is we are challenging the validity of the detainment, the validity of the arrest, which is the purpose. The actual purpose of habeas corpus is to challenge the validity of a detainment. It's a judicial relief. You're going to a judge and saying this state didn't have the authority to be able to deprive me of my liberty, therefore restore my liberties back to the point of deprivation. So this is, again, a judicial relief. And so it's important that you guys understand that the appeal looks at the end, looks at the judgment, right? And everything that's built up to that point. And yes, there could have been constitutional violations that occurred in the adjudication process, like perhaps an unconstitutional arrest, or maybe evidence that was suppressed, or bad counsel, or a biased judge, or malicious prosecutor, or over sentencing, or excessive fines. Any one of those would be constitutional violations that would be grounds for an appeal. Absolutely, right? But the problem is that when you look at effectiveness of what we're trying to do, we need as much attention on an issue, one single issue, not 50 issues, but one issue. So some of you are saying, yeah, my arrest was unconstitutional. Some of you are saying the prosecutor was malicious. Some of you are saying that the judge was biased. Some of you are saying that they suppressed evidence and denied me my right to be able to defend myself. All of those are real, tangible injustices that happened. But the problem is that when we look at the chain of events, starting from the arrest, through the investigation, through the trial or plea bargain, through the sentencing, through the imprisonment and fines and post-conviction relief and all those, that's a long period of time. And so we got, a million people talking about an issue here. We have 500,000 people are talking about an issue here. We have, 250,000 people are talking about an issue right here. And we have all of you spread out amongst a whole bunch of different issues that's talking about the injustice that's happened to you. But if the issue at the beginning was, did the state have the constitutional authority to be able to be both accuser and judge in the same cause? Can the state be both accuser and judge in the same cause? The answer is no for all of you. Regardless of whether you believe the injustice was, in the sentencing, or the injustice was in the bias of the judge or the malice of the prosecutor, every single one of you are impacted by original jurisdiction. Every one of you, including the CPS cases as well. Because remember, in CPS, right, CPS is an agent of the state. They're paid by the state. They claim immunity from the state, right? They are enforcing the laws of the state. They are an agent of the state. So when the agent of the state brings an accusation of you having violated the laws of the state, then the state cannot also be judge in the case because of the obvious conflict of interest that exists and the codified obligation in Article 3, where it says that the only court that has jurisdiction is the United States Supreme Court. They have original jurisdiction. The state doesn't have original jurisdiction. The United States Supreme Court has that. So my point again is that just as Paul said in the book of Romans, he says you're all just a bunch of clanging cymbals making a bunch of noise. And the problem right now is that we're having a very difficult time keying in on the exact issue, the fundamental issue, the base issue, which would be the lowest in the process. Like where does the issue begin? Where does it start? Where does the injustice begin for all of you? whether it's malice of prosecutor, bias of judge, over sentencing, over excessive fines, whatever it might be, where does that injustice begin? And it begins when the state believes that they can that they can judge and have jurisdiction over a case in which they themselves are party, right, through one of their agents. So that's where it begins. That's where the injustice for all of you begins. But we're making a lot of noise across a whole bunch of different issues along the way, right, through the whole adjudication process. And what happens there is that we're spreading thin our argument. We're not zeroing in. We're making so much noise that we don't know where to actually look, right? We don't know where the foundation is flawed. And so if the people step back, if you guys step back from your argument of bias of the judge or malice of the prosecutor, or excessive fines or suppression of evidence, all of these things that is after the moment in which the state took action in a case in which they had no lawful authority to take action in, because the Constitution does not grant jurisdiction onto a state when a state is a party, then we can all come back to that one issue. We can reduce the noise level across all these other issues by not talking about them and talking about the foundation. Where was the foundation flawed? The foundation was flawed when the state decided to abridge the limitations of power that the Constitution of the United States of America provides, and the Supreme Court of the United States failed to fulfill their duty or obligation of being the court of original jurisdiction anytime the state is a party, right? So I want to hit this again, all right? Anytime that you want to understand the Constitution of the United States, the provisions, and why our founders and forefathers wrote the provisions the way that they did, we would typically go to the Federalist Papers, right? Federalist Papers. And what the Federalist Papers were they were newspaper articles, right? That were put into place because the drafters of the Constitution, what was known as the Federalists, were having a difficult time getting it passed. The state of New York in particular was dragging their feet on it because they weren't sure if they wanted to adopt it and ratify it and move from a confederacy into the Union and fall into the supremacy of the Constitution. They were largely a statist, which put emphasis and power at the state level and limited the power of the central government, which was contrary to the Federalist point of view. The Federalist view, which was, James Madison and all the people who went to the Constitutional Convention, they were known as Federalists, which was looking at a strong central government that would be able to hold together all of the regional governments, right, through a standard set of laws. How do we keep all of these 50 regional governments together when they all have their own individual local interests and views? And that's why they put the emphasis onto the central government with the Constitution. And that's why they said that it's the supreme law of the land, because it's the only thing that holds the nation together. It's the only thing that binds it together. Absent the Constitution, there is no union. Absent the Constitution, there's nothing that connects California to New York or Alaska to Florida. There's nothing that does it other than the Constitution of the United States of America. That's what created the Union. So absent the Constitution, we lose the Union, and we lose the ability for the states to operate under a single set of laws that bind it all together. But so to understand the provisions of the Constitution, we would go to the Federalist Papers, written by John Jay, Alexander Hamilton, and James Madison. Guys, James Madison is considered the father of the Constitution. He wrote the main body of the Constitution. He did the first draft of the Bill of Rights. He was extremely prolific writer at that point in time, and most of, including Congress, most everybody went to him to do the writing. He was extremely well at it. But he's considered the father of the Constitution. And in fact, Supreme Court Justice Gorsuch says that he is the one single authority that they would turn to understand the Constitution as it was drafted at the time of its adoption, right? The intended purpose of it. And that's very important as well, because remember, we have 6 textualists or 6 originalists sitting on the court, meaning that they're going to look at the original intent of the Constitution to determine, the outcome of the dispute. Whatever dispute there might be at the Supreme Court, 6 of those justices say that they're textualists, and they're going to go to the original intended purpose of the Constitution to determine the outcome of the dispute. We're going to test that, right? We're going to find out if they're really textualists, Mr. Gorsuch, Mr. Thomas, Miss Barrett, but even the non-textualists, even the other than the six, we're going to have great support from Sotomayor because of the overrepresentation of Hispanics within the prison population, right? And she represents the Hispanics, so we're most likely going to be able to carry her as well on top of the six, but also Justice Jackson Brown, because Jackson Brown is first. She's the first black female that serves on there, but she's also the very first criminal defense attorney to have ever sat on the United States Supreme Court. So she knows the things that we're saying are true. And in fact, she actually made reference in a dissenting opinion about a year and a half or 2 years ago. She made a statement that she's tired of the court's no-see-um doctrine with regard to considering the innocence of prisoners. So we know that she would support this as well because she's, of course, tired of the no-see-um doctrine that they have with regard to considering the innocence of prisoners. And what we're doing is we're coming forward and saying, yeah, we know that there's an inordinate amount of people imprisoned here in America. But why are they imprisoned here in America? Well, they're imprisoned because of the over-concentration of power that the prosecuting attorney and judicial officer has, because they bypass the one procedure that exists to protect the innocents from hasty or malicious charges by an overzealous prosecutor, right? So I think we're going to have a unanimous decision. I think we can easily reach that unanimous decision. The only one in question would be Kagan, but I think we could easily have her as well. But nonetheless, if we rely upon the belief that the originalists are going to side with the original intent of the Constitution, then let's see what James Madison had to say, the father of the Constitution. Let's see what he had to say about this Article 3 provision that he wrote, right, that says that any time the state is a party in a cause, that the Supreme Court of the United States has original jurisdiction. Let's see what he had to say about it. To find that, we would go to the Federalist Papers Circular number 10, right? So number 10, guys, again, go out and get this information for yourself. Confirm what I'm saying to be true, right? Because everything I'm saying is absolutely real. It's tangible. It's true. You guys can go and you can find this yourself. So Federalist number 10, right? And this is the earliest known reference to the modern day concept of conflict of interest. You guys are all talking about how it's a conflict of interest for a judge to oversee a case in which he works for the plaintiff, right? Yeah, that's an obvious conflict of interest. But this particular writing was the earliest known reference to the modern day concept of conflict of interest, all right? James Madison was formulating his idea of conflict of interest from this particular writing. You'll hear from the words that he wrote. But this was in the Federalist Paper, Circular number 10. It was New York Packet, November 23rd, 1787. The article was titled "The Union as a Safeguard Against Domestic Faction and Insurrection." And in that article, what James Madison said is, no man is allowed to be judge in his own cause, because his interest would no doubt bias his judgment and not improbably corrupt his integrity. With equal, nay, with greater reason, a body of men are unfit to be both judge and party at the same time. So again, no man is allowed to be judge in his own cause. That is the maxim of law that is attached to that the state cannot be judge of its own case, right? No man can be judge of his own cause, because just as he said, his interest, conflict of interest, his interest would no doubt bias his judgment and not improbably corrupt his integrity. With equal, nay, with greater reason, a body of men are unfit to be both judge and party at the same time. So the state is made up of a body of men. That body of men has prosecutors, has law enforcement, has judges, has CPS, commissioners, senators, congressmen, right? This is all the body of men that make up the state. So a body of men are unfit to be both judge and party at the same time, in the same way that no man can be judge of his own case because of the obvious conflict of interest that exists, because he himself is accuser and judge. This is the maxim of law that you guys need to rely upon. Okay? No man can be judge of his own case. A body of men cannot be judge of its own case. So when an agent of the state brings an accusation against you, that same body of men cannot be presumed to be neutral and unbiased to act as the judge against you. Therefore, our founders said that that is a conflict of interest, and now they had to find a new court that would be able to oversee that particular dispute. right? And they decided that it was the Supreme Court of the United States. That's what was assigned and created by Article 3. Article 3 says, and it assigns the duty. It's the law. So if the Supreme Court of the United States says, yeah, we're not going to do it, then the Supreme Court just abused their discretion to break the law, right? And that makes what they've done unlawful. But more importantly, if a state takes action in a case in which they don't have jurisdiction, then nothing that that court does is lawful because the court never had authority to do it. Now, again, this goes back to a lot of people saying, well, when you walk into the courtroom, you grant them jurisdiction, and that's not true. It's not true, you guys. It can't be true because jurisdiction comes as a first duty to the court. You guys all know the corpus secundum, where the attorney's first duty is to the judiciary machinery, right? You all know that. Well, in the same way that the attorney's first duty is to the judicial machinery and protecting it, not to the client, the first duty to the court is to the jurisdiction. Because absent jurisdiction, that court can't exist. It can't speak the law. Again, you got to look at the timeline. You got to look at the steps. The people of the United States, we in our sovereignty created the Constitution. The Constitution then created jurisdiction, right? Original and appellate. Article 3. That jurisdiction then granted the state authority or not authority to speak the law. It granted them the authority to create a court or nothing at all. Absent jurisdiction, that is not a court. And absent a court, they can't create a court's agent. That's not a judge because there can't be a court because jurisdiction was not given to the state. So just because the agent calls you into the courtroom and you walk into the courtroom doesn't grant the court jurisdiction because jurisdiction comes before you walk into that court. That is either a court under lawful authority to speak the law or it's not. Just because you walk into it doesn't make it a court. You can't grant jurisdiction onto it because jurisdiction is statutorily imposed by the Constitution of the United States of America. So just because you walk in the courtroom, you do not grant them jurisdiction. Now, a lot of people argue that you grant them jurisdiction from right to contract. And that is true. You all have the right to contract. But before you have the right to contract, the court would have to breach their contract of the Constitution of the United States of America in order to allow you to contract with them. Therefore, by the breach of the constitutional contract to get you to enter into a contract, they would void both contracts because you cannot breach the terms of a contract. You can't break a duty or an obligation in order to create a new contract without voiding both contracts. That's very simple contract law. So again, right? If a court takes action in a case in which it lacks jurisdiction, what it produces is nothing at all because it derives from an entity that does not have the authority to speak the law, to create anything. And so this is also the reason why my affidavits, the affidavits that you guys are downloading from www.justicewithoutlimits.org, and you're sending them to care of Justin Carey in North Carolina in the Bridgeton address that is all contained within the instructions that you can also download from justicewithoutlimits.org. That affidavit, it does not identify a person in their official capacity. It doesn't ask for a judge because there isn't a judge. There is a person portraying themselves as a judge because the court does not have authority to create an agent of the court. Without jurisdiction, that can't be a judge. Without jurisdiction, that can't be a prosecutor. Without jurisdiction, that can't be a law enforcement officer. Therefore, that you don't call them out in their official capacity. This is how we're getting around immunity, right? This is how we're bringing this case forward to the Supreme Court and bypassing the immunity limitation is because if jurisdiction is not granted to the state, if they don't have the authority to speak the law in this particular dispute, then they can't create an agent. That is no different than any other person. That's a person that believes that they have power, that they were not vested with power by law. Therefore, they're acting unlawfully, right? They're depriving of rights under a semblance of power. That is deprivation of rights under color of law. So we're not calling them out in official capacity because official capacity would be validating their position. They don't have a position because the Constitution didn't grant the state to have the authority that these judges believe that they have. Constitution didn't grant the state the authority to be able to prosecute because the court doesn't have the authority to adjudicate its own matter because no man can be judge of its own case. So James Madison, Federalist number 10, right? Earliest known reference to the modern day concept of conflict of interest. That's what he said about the issue. And again, 6 of the justices are going to be going to him to say, okay, well, what did he have to say about it? Why did he write this? And they're going to be able to read right there. Federalist number 10. But again, maybe that's not enough. Maybe I'm misinterpreting, the reading of the sentence in all cases in which a state shall be party to the Supreme Court shall have original jurisdiction. Maybe I'm misunderstanding what James Madison said when he said that a body of men are unfit to be both judge and party at the same time. Maybe I'm not clear with them. Maybe we need to find another witness, right? Maybe we need to find another drafter of the Federalist Papers that attest to this particular issue. We find that with Alexander Hamilton in the Federalist number 80. Again, guys, go out and get this for yourself. In the Federalist number 80, Alexander Hamilton made 2 references to this issue. 2 of them, not just 1, but 2. The first reference that he made was that the federal judicial authority of the Union must extend to all cases between a state and the citizens thereof. If there is a dispute between the state, an agent of the state, if the state is a party to cause, if there is a dispute between a state and the citizens of that state, the federal judicial authority of the Union must extend. In other words, federal court, right? Federal judicial authority of the Union. Not the state judicial authority, but the federal judicial authority of the Union must extend. Thus, the United States Supreme Court, because Article 3 only created the Supreme Court. There wasn't a district court that was created by Article 3. Therefore, the federal judicial authority of the Union that Alexander Hamilton was referring to had to have been the Supreme Court because there was no district courts at that time. There was no circuit courts. Those were created later. So when he says that the federal judicial authority of the Union must extend to all cases between a state and the citizens thereof, he's referring to the United States Supreme Court. Thus, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. The federal judicial authority must extend anytime the state is a party to cause, right? So the second reference that Alexander Hamilton made in the Federalist number 80, attesting to this issue, is he said that state tribunals cannot be presumed to be impartial when they speak for themselves. No man ought certainly be a judge in their own cause or in any cause with which they have the least bit bias or interest. Now that sounds an awful lot like what James Madison said, right? No man can be judged in his own case, right? Right? And Alexander Hamilton said, no man ought certainly be a judge in his own cause or in any cause with which he has the least bit bias or interest, right? Once again, conflict of interest, least bit bias or interest. But the sentence that came before that was pretty clear. State tribunals cannot be presumed to be impartial when they speak for themselves, right? The state cannot speak for itself on its own issue. Therefore, when an agent of the state brings an accusation against you, the same body of men cannot be presumed to be impartial and unbiased to act as a judge against you. Thus, Alexander Hamilton confirms what we're talking about, even with James Madison there. So now we have 2 of the drafters of the Constitution, right? Very well-known names. Alexander Hamilton, James Madison. Doesn't get any more, any more known than that from our founders. We now have 3 references to this issue within 2 of the Federalist Papers. Well, the third drafter of the Federalist Papers was a man named John Jay. John Jay was sick during the writing of the Federalist Papers. He didn't make any particular reference to this issue within the Federalist Papers, but he did go on to become the first Chief Justice of the United States Supreme Court. And he did make a reference in a particular ruling that they made, called Martin versus Hunter's Lessee. Martin versus Hunter's Lessee. So he didn't make mention within the Federalist Papers, but we have a drafter who went on to become the first United States Supreme Court Justice. And what he said in Martin versus Hunter's Lessee is the Constitution has presumed that state prejudices, state biases, and state interests might from time to time obstruct the administration of justice by state judges. Therefore, it is the case and not the court that grants jurisdiction to the Supreme Court. It is the case and not the court, because Article 3 says, in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. So again, what he said is the Constitution has presumed that state prejudices, state biases, and state interests might from time to time obstruct the administration of justice by state judges, right? In other words, the judge will side with state interests, will do what the state is, what's in the best interest of the state, because he's part of the body of men that make up the state. He's seeking to advance the interests of the state. So John Jay said, state prejudices, state biases, and state interests might from time to time obstruct the administration of justice by state judges. Therefore, it is the case and not the court that grants jurisdiction to the Supreme Court. What they were getting at here was that people were being told, oh no, you need to go to the lowest court. You got to go to them, and you got to get a decision from that lowest court first before you can go to the Supreme Court. Just like all of you are being told you got to exhaust remedies. You got to get a decision from the highest court in the state before you can bring it into federal court jurisdiction. And what John Jay was saying there was, no, it's not the court that grants jurisdiction to the Supreme Court. It is the case that grants jurisdiction to the Supreme Court. Because the Constitution says in all cases in which a state shall be party, not in all courts that grant jurisdiction, but in all cases. And a case, you guys, is nothing more than two parties, moving, respondent. That's the case. The case initiates the two parties. And if a state is a party, then the state cannot be judge. It does not have jurisdiction, because it is the case and not the court that grants original jurisdiction to the Supreme Court. Okay? It is the case and not the court. So when the court tells you, like the district court, you guys bring your case to the United States District Court. You're bringing an appeal. You're appealing to the district court, and that district court says, oh no, you got to go back to the state. You got to get a decision from the state Supreme Court. And until you do, we don't have jurisdiction. Well, the problem there is that the district court doesn't have jurisdiction at all. It has no jurisdiction because the Constitution doesn't give it jurisdiction. Nor does the state have to make a decision in order for the Supreme Court to have jurisdiction, because the Constitution assigns original jurisdiction to the Supreme Court of the United States. It's not the court that grants jurisdiction. There are no remedies that must be exhausted to go to the United States Supreme Court, because the duty exists for the Supreme Court to hear it. The law obligates the Supreme Court. Obligates. Now, this has been forgotten over years, because in 1793, this particular issue was litigated at the United States Supreme Court. It was the first case that the court ever heard. It was called Chisholm versus Georgia. This issue has already been resolved, right? Yes, the Supreme Court has original jurisdiction, but it's been forgotten. It's been forgotten for a lot of different reasons, one of which is, again, the 1925 Judicial Reform Act, where Congress, the United States Congress back then, was trying to cover up and hide the illegal rulings and unlawful decisions that were put into place by the Supreme Court, because they didn't want to have to address them. So, once they found out that the Supreme Court had put into place a number of unconstitutional rulings, such as Hurtado versus California, where they say that California doesn't have to follow the Constitution of the United States, right? When the United States Congress in 1925 found out that the United States Supreme Court has not been following the Constitution, has not been requiring the states to obey the limitations of power of the Constitution, they came up with this idea. Well, we'll enact the 1925 Judicial Reform Act, and we will first off make it so that the courts are all courts of discretion. Because if we tell the people of the United States that the Supreme Court is a court of discretion, then that means, Supreme Court, you don't have to address these big issues here. We can keep it hidden because you can just ignore it, Supreme Court. You'll never have to make a decision. So when one of these issues come forward, such as a challenge to Hurtado, right, then they can say, oh, we don't have to hear that. and thus keep on advancing this fraud that was created by the court. So we have collusion that existed from the United States Congress, because that was what they did. That was a decision that they made to cover up these unlawful acts by saying Supreme Court is now a court of discretion, and now they're able to pick and choose whether or not they want to hear a case, and thus we will never get action on these civil rights violations that are clear and obvious, absolutely clear and obvious, because the court's a court of discretion. But again, that court cannot be a court of discretion so long as the state is a party, because that's an obligation, right? And you can never use discretion with regard to one's constitutional obligations. Obligations must be performed, otherwise you are using your discretion abusively to break the law. And anytime any public official abuses any discretionary authority with which they are invested in law, they commit 3 crimes automatically. These are per se crimes, meaning that all elements of the crime have been met the moment that we show that there was an obligation and they didn't fulfill the obligation. They broke the law. The first crime is perjury, because they made a promise that they would do something. They would obey the Constitution. They're bound by anything in the Constitution. Bound means that they're obligated. It creates a duty, right? And when they fail to fulfill the duty, they have already implicitly invited punishment in the form of perjury should they fail to fulfill the promise that they made. That's the effect of the oath. So if you promise a future outcome and you fail to fulfill the promise, then you have already implicitly invited punishment in the form of perjury should you fail to fulfill that promise. Perjury is punishable by 5 years imprisonment with every offense. Every single time that you commit perjury, it's 5 years, right? The other thing it does is it is a violation of public trust, meaning that you can't be trusted by the public to fulfill your obligations because you're a liar. And thus you can never hold public office ever again. That's the effect of the oath. Right? So it's automatic. Anytime anyone abuses any discretionary authority with which they're invested in law, commit 3 crimes. Perjury. The second crime is extortion. Extortion is compelling a result through illegal means, right? So they are compelling a result through the abuse of discretion. They're breaking the law and thus bringing about a desired result through an unlawful act. They're breaking the law to bring about a desired outcome, right? So you can never compel a result through illegal means. You can never abuse your discretion to break the law and thus produce an outcome, compel a result through your illegal means. So that's the second crime, automatic. All we got to do is show they had an obligation in the Constitution and they didn't fulfill that obligation. And again, these are per se crimes. They're guilty of perjury and extortion. They can never hold public office again. And how many times have they committed perjury, every single day when they continue to refuse to recognize and enforce the law? And this is also what I keep on bringing up in these services that we're doing, that Jessica and I are doing, is I keep on bringing up the abuse of discretion, right? And so the United States Circuit Court has identified a 2-part test that is used to determine an abuse of discretion. It's a 2-part test. Don't worry about the first part. It is important, but not important right now. But the second part of the test says that any erroneous view of the law is an automatic abuse of discretion. So again, any erroneous view of the law is an automatic abuse of discretion. Now, an erroneous view of the law would be that in a judge's legal contemplation, that the lowest form of law, a judge-made ruling, is superior to the Constitution of the United States of America. That would be an obvious erroneous view of the law. Therefore, an automatic abuse of discretion has occurred every time they do it. Now, likewise, right, when a judge or a prosecutor relies upon an inferior state statute that says you don't have to have an indictment by a grand jury, when they rely upon that inferior state law to abridge the obligations that they have codified in the Constitution of the United States of America, Clause 1, Amendment 5, then that is an obvious erroneous view of the law as well. They believe that the inferior law is superior to the supreme law of the land. That is an obvious erroneous view of the law. Therefore, an automatic abuse of discretion has occurred. And this is also a crime is punishable by a significant amount of time, especially when you add the crime of kidnapping. Because again, let's look at this rationally. If the state did not have the authority to speak the law, then that means that the state has no authority to create a court. That court has no authority to oversee the disposition of dispute. The court has no authority to order your arrest or order you to come in and be summoned in to stand trial, to be held to answer. Therefore, the moment that they take you into custody, they are holding you against your will, which would be the crime of kidnapping. But what makes it a federal kidnapping offense is any time that you are held for ransom, that is always a federal kidnapping offense. Anytime that there is ransom involved in a kidnapping, that is always a federal kidnapping offense. That's Title 18, subsection 1201. And your ransom, all these people, even your children, right, are being held ransom in the form of child support, right? In the form of fines, in the form of you got to pay someone in order to visit. This is all ransom that they're employing against you. They're extracting money from you through illegal means. And then they've taken your child and they say, we're going to hold this child ransom until you pay us, right? Or we're going to hold you ransom until you pay the bail. This is ransom. That's what this is. That's what makes it a 1201 offense. And this is significant because, of course, anytime that anyone deprives a person of a right that's protected by the Constitution under the semblance of a law, right, under an inferior state law, anytime you have kidnapping that's in conjunction with that, the punishment is as prescribed by law, death. This is a very serious offense. This is an extremely serious offense, what they're doing, right? Because it is a capital offense, what's happening here. If you kidnap someone in conjunction with a deprivation of rights under color of law, according to the law, the punishment is death. This is a serious offense. Serious. And there's no denying it. Now, the third crime that every public official commits who abuses any discretionary authority with which they're invested in law is the crime of official oppression. Official oppression, right? Official oppression is applying the law unequally against like members of society. Okay, so the way that this works is that judge allowed for that person to have an indictment by a grand jury, but this person does not. He held this person to answer with an indictment by a grand jury, but this person, he did not. And in doing so, now he is applying the law unequally against like members of society, and that is known as official oppression. Likewise, when you come into the courtroom, that judge said, oh, you mother are going to have full and complete access to your child without governmental interference, but father, you get no access to your child. You don't get to see your child, but you do, mother. And that is taking the law and applying it unequally against like members of society, right? Because the law protects the right of intimate association. The law protects your right to have an intimate familial relationship with your child without governmental interference. And that right extends to both mother and father. So the judge's role is to protect the relationship, right? The obligation exists because the right exists. The judge's obligation is to protect the right. And if the right is that government can't interfere with a familial relationship, then that means that the judge can't interfere with either one of the two relationships, right? But yet that's what they're doing. They're applying the law unequally against like members of society. So there are three crimes that are automatically committed every single time that any person abuses any discretionary authority with which they are invested in law, right? One of those crimes, of course, is a crime of public trust, meaning that they can no longer be trusted to fulfill their obligation and thereby discharged. Now, so again, the way that this is all working, right? Because ultimately we are moving to invoke original jurisdiction with the United States Supreme Court. That's what we're ultimately going to do. We're going to invoke original jurisdiction under a writ of habeas corpus because it's judicial relief. We're not bringing a writ of certiorari because we are not validating a judgment, because if the court or the state didn't have the authority to oversee the disposition of dispute, then there is no judgment. What is it that you're going to appeal, right? If the court doesn't have jurisdiction, if the state was not granted jurisdiction, then what are you appealing, right? There's nothing to appeal because it's void. So when you deal with the voiding of judgments, you got to go to Civil Rule 60, right? Civil Rule 60 deals with the nullification or voiding of judgments. Nullification and void are two different things, right? They're two different things, the nullification or voiding of the judgment. Now, if you go to Civil Rule 60, B4, that's boy 4, Civil Rule 60, B4. What B4 says is it says that a judgment is either valid or it's void. It can't be anything else. It's either valid or it's void. It cannot be anything else. If the judgment is valid, you have to appeal it. You have to, because it's a valid judgment, right? But if the judgment is void, it's as though it doesn't even exist. It was never valid. It can never become valid. No court can change it. No duration of time can do it. No subsequent law can render it valid. A void judgment is always and forever void. It can never become valid. Okay? So a judgment is either valid or it's void. So if it's a valid judgment, well, you need to go to Civil Rule 60, B1, 2, 3, 5, and 6 to be able to decide, well, how do we deal with this valid judgment? And that would have to go through a writ of certiorari because you have a valid judgment, meaning that the court had jurisdiction, it had subject matter jurisdiction, it had personal jurisdiction, it had the authority. That judge was lawfully appointed a judge and lawfully able to be the judge and oversee the disposition of dispute. That's what that means. So if the judgment is valid, yeah, you have to appeal it. But if the judgment is void, you don't have to appeal it. There's nothing to appeal. And according to Civil Rule 60 B4, a judgment is either valid or void, can't be anything else. It is valid in all instances except for when the court rendering the decision lacked either subject matter jurisdiction or personal jurisdiction. If the court lacked either subject matter jurisdiction or personal jurisdiction, that judgment is void. Void, V-O-I-D. Not nullified, right? Not appealed, not rendered. It's void. Because the court that rendered the decision did not have the authority to be a court. The person that oversaw the disposition of that dispute didn't have the authority to be in that position because they lacked jurisdiction. Now, why would an agent of the court, why would the judge lack jurisdiction, right? Court lacks jurisdiction because the Constitution doesn't grant it jurisdiction. But where does the agent lose its jurisdiction under personal jurisdiction? You can find that under the automatic recusal code of Title 28. This is Title 28, USC subsection 455. That's 455. 455. What 455 says is it says that a judge, and again, this applies quite simply to federal judges. There is no federal judge in America that can say, oh, Title 28 doesn't apply to me. None. So all federal cases are easily addressed by this particular statute. State courts, that is what we're arguing, that's what we're fighting is, does Title 28 apply to states? And it does, but the states don't want it to because that would mean that the judges can't oversee this. Because Title 28 USC subsection 455 says that a judge has a mandatory, non-waivable, self-executing duty to recuse himself if he is an officer of either party. If he's an officer of either party. These are judicial officers of the state who just so happens to be a party in the case. State of Washington versus Bob, that judge is a judicial officer of the state of Washington. Therefore, he has an automatic, mandatory, non-waivable, self-executing duty to recuse himself because of the obvious conflict of interest because he is an officer of either party, right? An officer by the party. Now, when a judge fails to recuse themselves when they have an automatic recusal, according to Cohen versus Virginia, according to Hill versus Weeks, that judge is now warring against the Constitution and committing the crime of treason. Already litigated, right? Anytime that a judge takes action in a case in which they have an automatic recusal, that judge is now committing the crime of treason. Cohen versus Virginia, Hill versus Weeks. All right. So the automatic recusal says that you have an automatic, right? That's automatic under 455, automatic, non-discretionary, right? They can't use their discretion to say, well, yeah, I'm going to take jurisdiction. I'm going to continue to oversee this because it's non-discretionary, right? It is self-executing. Self-executing means they got to do it. You don't have to ask them to do it. They have to do it, right? Because it's self-executing, right? You don't have to make a motion to ask the judge to recuse himself because it is a self-executing duty. They must do it on their own. So again, judge has a mandatory, non-waivable, self-executing duty. And what is a duty, you guys? What is a duty? A duty is what you are obligated to do or forbear from doing based upon the law, right? So if the law tells you you must do something or forbear from doing something, that is a duty. That's why the Constitution says the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The word bound is extremely important because the word bound applies to something that a person must do. That's what they're bound. They're bound by law. So a duty can be seen from two different perspectives. An obligation. An obligation refers to something a person is bound to do or forbear from doing. An obligation, bound to do or forbear from doing. So when the Constitution says the judges in every state shall be bound thereby, anything in the Constitution, what it says is that they are obligated. An obligation refers to something a person is bound to do or forbear from doing. An obligation can be seen from two different perspectives, okay? Two different perspectives. From the one bound, the obligation is a duty. From the one entitled, the obligation is a right, okay? So if the law says, judge, you're bound by whatever the Constitution says, then when the Constitution says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, that means that the judge is bound to ensure that you are not held to answer without an indictment by a grand jury. That is seen from two perspectives. From the one entitled, the obligation is a right. From the one bound, the obligation is a duty. So when you have a duty to do something or forbear from doing something and you fail to fulfill the duty, you just broke the law and thus violated the right of the one entitled to the fruits of the obligation. We all have the right to have an indictment by a grand jury before being held to answer for a capital or otherwise infamous crime because the judge is obligated to do it. He has a duty to do it. And if he breaches his duty, he has just broken the law, giving rise to injunctive relief for you to be able to seek a remedy for the breach of obligation, the promise that he made. He's guilty of perjury, guilty of extortion, right? Because he didn't do what he promised to do. So Title 28, subsection 455, automatic recusal. In the federal judiciary, for all of you that have had federal crimes or federal charges, and perhaps you are going through it right now, the issue again at hand is Title 28 applies to every single federal judge. No denying that. Every single federal judge is bound to obey Title 28. State judges are also bound, but for sure, right up the top, no matter what, every federal judge must obey Title 28. And when Title 28 says that the judge has a mandatory, non-waivable, self-executing duty to recuse himself anytime that he is an officer of either party, well, that federal judge is a judicial officer of the United States. So when the United States of America is a party, then that judge has just acted without jurisdiction. because they have a mandatory, non-waivable, self-executing duty to recuse themselves. Failure to do so means that they're now warned against the Constitution, committing the crime of treason. Cohen versus Virginia, Hill versus Weeks. Every single federal judge has a mandatory obligation, a mandatory duty to recuse themselves under Title 28, subsection 455, if they are an officer of either party. So when the moving party is the United States of America, then a judge of the United States of America cannot oversee the disposition of that dispute for the same reason that a state judge can't oversee the disposition of a dispute when the state is a party. It's no different. See, this illustrates the complexity of the Constitution and what our founders actually put into place under our foundational law. If the state is a party in the cause, the federal judicial authority must extend, meaning the federal court must oversee it. But in this case, the obligation exists for the Supreme Court to oversee it. So if a state is a party in a cause, United States Supreme Court must oversee it. That's the only court with jurisdiction, personal jurisdiction, to oversee that dispute, because the Constitution says if the state is a party, that's the only court with the authority, lawful authority to oversee the parties involved in the dispute. Doesn't matter who it is, me or Tom or Bill or Sandy, the other party doesn't matter. What matters is, was the state a party in the cause? And if they were, personal jurisdiction is assigned to the United States Supreme Court. No other court has personal jurisdiction to oversee a case in which a state is a party. Doesn't matter whether they're moving party or defendant, doesn't matter, because it says in all cases in which a state shall be party. That does not identify the state as the respondent or the state as the petitioner. It says if the state is a party, doesn't matter which side, because remember, simply rearranging the order of the parties does not magically change the representation of the parties. That's Law 101. That just because the state of Washington is the respondent doesn't make the state of Washington any different than when the state of Washington is the petitioner. Therefore, the position of the party in the case does not change the representation of the parties. If the state is a party in the cause, either moving or respondent, petitioner or defendant, then the United States Supreme Court has personal jurisdiction to oversee the parties involved in that dispute, because the state cannot oversee its own case. No man can be judge of his own cause, right? Very, very simple. So, where was I going with that? So, I was going with, there was something with that. I don't remember here. So, so if the state is a party in the cause, so the federal judges. So the federal judges are actually easier than the state judges, right? The states are bound to obey Title 28 just as much as the federal judges. But all of you that are going through a federal case, that is a judicial officer of the United States of America. Therefore, the United States of America does not have the authority to oversee it. So again, the way it's supposed to work is when a state brings an accusation against you of having violated the laws of the state through one of its agents, a prosecuting attorney, police officer, whoever, the same body of men that represent the state cannot be presumed to be impartial to act as a judge against you. And the Constitution has said that the Supreme Court of the United States has personal jurisdiction. Okay? So that's easy. State is a party, federal court has jurisdiction to oversee it. It's a different government, right? State can bring an accusation, but that means the state can't judge. State brings an accusation, federal court must be the judge. Different government. Now we have limited powers. But likewise, federal government brings an accusation against you, that judge has to recuse himself because of the automatic, mandatory, non-waivable duty to recuse. Therefore, who can be the judge? The state. That's why Article 3 says the trial of all crimes, with the exception of impeachment, shall be by jury, and the trial shall occur in the state where which the crime is said to have been committed. Because if a crime is committed, right, a federal crime, and the federal government brings an accusation against you through one of its agents, the U.S. attorney, if a U.S. attorney brings an accusation against you, that judge has a mandatory, non-waivable, self-executing duty to recuse himself. Therefore, no federal judge can oversee the disposition of that dispute. The only judge that can then would be a state judge, a different government, right? Different government. This is the limitations of power that the Constitution provides. So all of these federal cases are actually the easiest of all, because that judge has a mandatory, non-waivable, self-executing duty to recuse himself because he's an officer of either party. Now, one thing that you guys are going to find is that now that I put this information out there, right, we're going to find that they go and they change this information quite often, right? They go in and they change the law. They amend the law, right? Because they just go in and they just delete what I'm saying and put in something different. They've done it numerous times. But that's called an ex post facto, right? Just because they changed the law today doesn't mean that it applies retroactively to you yesterday. So if Congress comes in and says, well, we better change Title 28 because Tanoa Downing figured out that all these judges are officers of the moving party, therefore they're all void. Well, let's change it so we can say, oh, well, that it doesn't matter. Well, no, because the law said something today. They can't get rid of all of the evidence, right? There's billions, millions of Black's Law dictionaries out there that's going to show that up until this date right here, it said that there's an automatic, mandatory, non-waivable self-executing duty to recuse themselves. Therefore, all the cases where a judge took action in which they had an automatic recusal, they're all void. They're all void because the judge had to commit treason in order to do it. And again, any time that a court acts without jurisdiction, when the officer of the court acts without jurisdiction, what it produces is void. That judge had no authority to oversee the disposition of the dispute. Therefore, what they produced is void, fully, without force or effect under Civil Rule 60b-4, because anytime a court acts when it lacks subject matter or personal jurisdiction, what it produces is void, as though it never even existed, right? So these are all facially void, unconstitutional judgments because the court rendering decision didn't have the lawful authority to render it. It's in violation of the Constitution because of the conflict of interest that exists. No man can be judge his own case. No more can the state oversee its own case and act as the judge and be presumed to be impartial. Can the United States of America oversee its own case and be presumed to be neutral and unbiased to act as a judge? So the Constitution was designed to provide these limits of power. In some cases, federal government's powers are limited. In other cases, state powers are limited. In more cases, both governments' powers are limited, but they're all limited in order to preserve the individual liberties of the people. So again, the way it's supposed to work is if the state creates a law and brings an accusation through one of its agents that you have violated the law, thus these victimless crimes, the state becoming a party, the state becoming the victim, great. Then the state can't be judge. Can't be judge. Because that judge is an officer of either party. There has to be a victim. Who's the victim? Tell me who the victim is. Show me the victim. And judge, if there is a victim, then yes, you could probably oversee that lawfully because the state isn't a party. But if the victim is an agent of the state, then you can't oversee it, judge, because you cannot be presumed to be neutral and biased to act as a judge. You can't. And that applies to state government as well as federal government. You know, Duralex sed lex. The law is hard, but it's the law, right? You might not like it, government. You might not like the things I'm saying, but this is the law. And we got to follow the law because that's what obligates you to protect the liberties of the people. We're not going to budge on the law here, right? We're not going to budge on what United States Congress put into place if those acts are unconstitutional, such as the Judicial Reform Act of 1925. We're not going to obey it. When the judicial code says that the district court has original jurisdiction, we're going to say no. The Constitution says the Supreme Court has original jurisdiction. If I listen to Congress and I listen to what they say and I go and I break the law because someone told me to break the law, I can't claim immunity for that. Ignorance of the law is no justification for having broken it. I'm going to choose to follow the supreme law of the land and what it says because anything contrary to it is unconstitutional. The UCC is below the Constitution. If the UCC says something, I'm going to say no. Constitution of the United States of America says this. That's preemption. We all have to employ this preemption. Constitution is pretty easy, guys. It's 4 pages. 4 pages long. That's it. 4 pages. It's not hard to know what it says. But anything that's contrary to it would be unconstitutional. So in this jurisdictional argument that a lot of you are trying to bring forward, right? And you're all asking me, well, how do you do this? Well, I mean, you have to rely upon the supreme law of the land, what it says. Because anything that's contrary to it, including acts of Congress, including treaties, including state statutes or state constitutions or the UCC, all of it doesn't matter if it's contrary to the Constitution of the United States. And that's why I say that Anything that is not the Constitution is unconstitutional simply by virtue of the fact that it's not the Constitution. So anything that's not the Constitution is by its very definition unconstitutional. So if you want to act constitutionally, then you go to 4 pages of law. 4 pages, Constitution of the United States of America. You don't use anything else. You don't need to go to United States Code to back up anything. You don't need to go. All you need to do is go to those 4 pages and say, this is what the Constitution says. Right? This is that whole philosophy of fighting from the high ground. Right? If you guys haven't seen the analogy or heard the analogy, it's this, that, I used to be in military. I used to be special operations military. And there is a combat philosophy that exists that when you hold high ground, you're in a superior tactical capability, right? Whoever holds high ground is going to win the war or win the battle. If you hold high ground, you're going to win the battle, right? Because what you have to do is you have to draw the enemy up to your level. And the enemy can't fight on the way up because you have a superior tactical capability. You're shooting down on them, they're shooting up into the berm. So whoever holds high ground has a superior tactical capability. The Constitution of the United States of America is known as the highest form of law. Highest form of law. So when you get up on the highest form of law, you don't come down off of it to fight down in the weeds, down in case law or state statutes where they want you to fight. Judges and prosecutors and law enforcement and CPS, they all win down in the lower form of law. That's why they keep drawing you down. They say, oh, no. You come down off of the Constitution, you fight down here in judge-made rulings, right? Because they win in judge-made rulings. That's where they win. But when you get up on the highest form of law, you have a superior tactical capability, right? This is combat philosophy. So when you get up on the highest form of law, you don't come down off of the highest form of law to fight down the weeds. They're going to draw you down and you continue to draw them up. No, you stay in your superior position. You don't come down off of that. Get up on the highest form of law and stay there. What do I mean by stay there? I mean, when a judge says to you, this ruling says this, I'm going to say no. Constitution of the United States of America says no person shall be held to answer for capital or otherwise infamous crime unless on presentment or indictment of grand jury. And then they say, yeah, but this state statute right here, this state constitution says no grand jury shall be drawn or summoned in any county. I'm going to say, no. Constitution says no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of grand jury. And then they say, yeah, but the Supreme Court said in Hurtado versus California over here that the California and the states don't have to do what the Constitution said. I'm going to say again, no person shall be held to answer for capital or otherwise infamous crime unless on presentment or indictment of grand jury. Right? What I'm going to do is I'm going to continue to draw them up to my level. Because no judge, no prosecutor, no attorney can fight at my level. They can't fight at the level of Constitution. We defeat them as we draw them up to our level. So you guys, you need to get up on the highest form of law. You need to get up there. You need to stay there. Don't come down off it. They're going to try their best to draw you down. They're going to confuse you with state statutes. They're going to confuse you with judge-made rulings. You guys maintain the clarity of saying, you know what? No. I'm going to maintain the superior tactical capability, and I'm going to cite the Constitution of the United States of America, because anything contrary to that is unconstitutional. I don't give a shit what judge-made rulings say. I don't give a shit what state statutes say. I don't give a shit what UCC says. I give a shit what the Constitution of the United States of America says. I'm going to stay on my superior tactical capability. I'm going to stay up here, and I'm not going to come down off it. Again, what you're doing is you're trying to draw them up to your level. They're trying to draw you down into their lower level where they win. You draw them up to your level. And when you draw them up to your level, they cannot fight at your level. You will defeat them. That is a superior tactical capability. All right? So it does work. So all of you know, at least most of you would know, that when you go to the court, right, and you cite the Constitution, do they come back with a provision of the Constitution in rebuttal, or do they come with the judge-made ruling? They always come with a judge-made ruling, right? They never cite the Constitution. If I say Clause 1 of Amendment 5 says this, then they go out and they come back and rebut me with Hurtado versus California, or with Article 1, Section 2 of the Washington State's Inferior Constitution. They don't cite the United States Constitution. They cite other laws because they can't fight at our level. Because if they violate the Constitution of the United States of America, what they produced is unconstitutional. So what they're doing is they're drawing you down from your superior position, right? From the superior law. They're drawing you down and they're confusing you and making you think that you need to argue with them down at the lower level. And you don't. All you got to do is cite the Constitution. That's it. 4 pages. Very easy. And you keep drawing them up to your level. This takes a long time to do this, right? But again, any erroneous view of the law is an automatic abuse of discretion. So when the court, the Attorney General, perhaps in his memorandum of authority, right, rebutting your complaint of saying, I have a constitutional right that's been violated, and they come back and say, nope, this judge-made ruling says you don't. That is an erroneous view of the law. Because in that Attorney General's legal contemplation in the submission of the memorandum of authorities, he is believing that the lowest form of law, a judge-made ruling, is superior to the Constitution of the United States of America. That is an obvious erroneous view of the law. Therefore, an automatic abuse of discretion occurs. And again, there's 3 crimes that are associated with the automatic abuse of discretion. So your superior position is Constitution of the United States. Anything that is not the Constitution is by its very definition unconstitutional. The judiciary has no lawful authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution. The states have no authority to be able to amend the Constitution other than lawful manner. Hang on one second. Let's go ahead and get that guy blocked. Okay, so the only thing that we're getting back in feedback, right, in response to this complaint, we say, oh, well, Constitution requires it. It's not being done. 13 states are failing to comply with the enumerated requirements of the Constitution of the United States of America, right? The only response that we're getting back, the only feedback that we're getting back is Fifth Amendment doesn't apply to the states. You guys have all heard it. That's what Hurtado says. Fifth Amendment, the grand jury clause doesn't apply to the states. States don't have to follow that. They don't have to obey that. Well, they do. But that's the only feedback that we're getting. Let me ask you guys, right? To what purpose is the Constitution if it doesn't restrict and limit the powers of government? Why did the Constitution say that the judges in every state shall be bound thereby anything in the Constitution or laws of any state contrary notwithstanding? You see, the Constitution isn't referring to federal judges when it says state, because Article 3 says the judges both of the United States and of the several states shall maintain their office while in good behavior. So our founders identified that there were judges of the United States and judges of the several states, judges of states. So that reference in the Supremacy Clause where it says that the judges in every state shall be bound thereby anything in the Constitution, that wasn't referring to federal judges. That was referring to state judges, because the Constitution has identified that there was a difference between judges of the United States and judges of the states. If the Supremacy Clause said the judges and every judge of the United States shall be bound thereby anything in the Constitution or laws of any state contrary notwithstanding, then perhaps that wouldn't apply. The Supremacy Clause would not apply to state judges. But it didn't say that, and it doesn't. It says the judges in every state shall be bound thereby. So that is after, right? After our founders said that the judges both of the United States and of the several states, right, shall maintain their office while in good behavior. The Constitution has identified a difference in the judiciary between the states and the United States of America, and identified that there were United States judges and state judges. So when the Supremacy Clause says that the judges in every state shall be bound thereby anything in the Constitution, it was not referring to federal judges. And again, remember, a binding is binding them to an obligation. And the obligation can be bridged when they fail to fulfill the promise they made, when they fail to fulfill the duty. And the duty is codified in the promise they make to be bound by whatever the Constitution requires. So when you look at the Supremacy Clause and what it says that the judges in every state shall be bound thereby anything in the Constitution or laws of any state to contrary notwithstanding. So the question would be, is the Fifth Amendment part of the Constitution? Well, the answer there is yes, because it was adopted and ratified by the people on December 15th, 1791 in all intents and purposes, right? The Article 5 says that proposed amendments, once 2/3 of both House and Senate approve it, then it goes out to the states, and once 3/4 of the states ratify it through suffrage, then it becomes part of the Constitution in all intents and purposes. No one is refuting the fact that the Bill of Rights, the first 10 amendments, were lawfully ratified and adopted by the people. Therefore, they are part of the Constitution. So being part of the Constitution, are the judges bound to do it now? Absolutely, because they're bound thereby anything in the Constitution. Properly ratified, put into place in all intents and purposes, and the state judges are bound to do it. Right? Now, the other thing is does the state judge have the authority to use their discretion to say, no, we're going to follow the state statute? They don't, because of this issue of preemption, just as I've been saying. Preemption is when there is a conflict of law, then you must determine which law to follow. Because a law that is unconstitutional is not a law at all. So has never even existed. Refer to Norton versus Shelby County. Any unconstitutional law, be it a statute, ordinance, custom, regulation, is no law at all. It provides no protection. It creates no office. No person is bound to obey it. No court is bound to enforce it. It is as though it never even existed. That's Norton versus Shelby County, United States Supreme Court. So the unconstitutionality of a statute is not from the moment that it's deemed unconstitutional, but rather from the moment that it was created, as though it was never created at all, because it was always unconstitutional. No court is bound to obey an unconstitutional law. So when the Constitution states says that no person could be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, then that means that the states cannot create a law, right, without that says we're not going to do it, right? In other words, Article 1, Section 26 of Washington State's Constitution, no grand jury shall be drawn or summoned in any county, or the state of Oklahoma, Article 2, Section 18, that the prosecuting attorney can charge by information or indictment by their discretion. Both of those are unconstitutional because it is contrary to the Constitution. It's allowing them to to hold a person to answer for an infamous crime without the proper charging instrument, without the restriction in power. And that's why no state can create or enforce any law that abridges the privileges and immunities of United States citizens. So the unconstitutionality of a statute, now you got to bring in preemption. Because if I'm a judge, right? If I'm a judge and I swear an oath to a state constitution and the federal constitution, and then I say, oh, I'm going to follow the state constitution, which says I don't have to have an indictment by a grand jury, that law is not valid. It's unconstitutional, according to Norton versus Shelby County, because it's contrary to the limitations of power. But if I choose to rely upon it, what I'm doing is I'm allowing someone to tell me to break the law, and ignorance of the law is no justification for having broken it. That's why preemption must be employed. If there is a conflict of law, you have to determine which law you have to follow, because otherwise, if you follow the unconstitutional law, you just acted unconstitutionally. That's an abuse of discretion, right? That's treason. That's all of these crimes and that renders void the judgment because you didn't have authority to be a judge. Any crime removes subject matter jurisdiction. We haven't even talked about that. We haven't even breached that subject. We're still focused on personal jurisdiction. We haven't even talked about the crimes that are committed, right, that render void the subject matter jurisdiction, because the court can't have subject matter jurisdiction when they commit a crime. So if you can identify a crime, that removes subject matter jurisdiction. Now they don't have either subject matter jurisdiction or personal jurisdiction. We're still focused on personal because that's sufficient to be able to address this entire issue. But if a judge abuses the discretionary authority with which he's invested in law by an erroneous view of the law, by saying, oh, the state statute allows me to not do what the Constitution requires me to do, well, that would be saying I am abridging what I'm bound and obligated to do, because the Constitution says the judges in every state shall be bound thereby anything in the Constitution or laws in any states contrary notwithstanding. So the only feedback we're getting from anyone at all, is that the Fifth Amendment doesn't apply to states. That is a losing argument, right? That is a losing argument that the states are not going to be able to overcome. The only play that they have is to ignore this. And that's what they're doing. They're effectively doing it. Like, you guys know that. You guys can see that. They don't think that this is going to come forward. They think that they're going to be able to just let this slide and get by and whatever else. And you know what? That could very well be true. That could very well be true, right? But the thing is that we've identified them in an unlawful and an unconstitutional conviction or condition. We have the ability right now to render void literally millions and millions and millions of judgments in one single action. Can the state be both accuser and judge in the same cause? The answer is no. Therefore, personal jurisdiction doesn't exist. The judge had an automatic recusal, right? They took action in a case in which they lacked jurisdiction, committed the crime of treason, renders void everything that happens after that moment that it's determined that the court did not have jurisdiction, right? This is the ability to void millions of judgments. Not just judgments, but also charges. So, and we're not talking about just, from this moment forward. Again, Norton versus Shelby County says that any unconstitutional act is not unconstitutional from the moment deemed such, but rather from the moment was done, as though it was never done at all. None of these judgments are valid because the court that's rendering the decision lacks jurisdiction, because the agent is acting when they have an automatic recusal because they're an agent of either party, written in law. So, for those people that have already served their time, yeah, I mean, there's no magic time machine that's going to get you that time back. We can't give that to you. But does this affect you? Absolutely it does. Because the judgment that's in place, the restrictions that they have against you, all these limitations that are in place that are restricting your liberty, your ability to get a job and buy a car, and all these things are all void. Right? As though they never even existed, because the court that rendered decision had no lawful authority to do it. Every single federal criminal, and I'm not saying we're releasing dangerous people, don't get me wrong here, but this is a massive reconciliation of public debt. Public debt. That's what this is. Now, you may not see this debt as debt, but it actually is, because every single one of these prisoners have a debt that is owed to society, to which they're charged, called to account, so they can pay the debt. This slavery institution is based upon economics, is based upon debt. So what we're talking about here is a massive reconciliation and discharge of public debt. Debt that was not lawfully incurred, because the state cannot be the debtor, right? They can't say, oh, well, you owe the state this debt, and now we're going to require you to pay it, and now you're going to be our slave, and you will forever be enslaved into this institution because we're going to label you a criminal and place 90,000 limitations on your ability to be able to be free. Go get a job and car and house and all these other things, right? So what I'm saying is that for all the people that have served the time, yeah, you're not going to be able to get your time back. That life is not going to come back to you. But what this will do is this requires them to return you to the state to the point in which the breach of fundamental right occurred, which was the moment of rest. So everything that they did after the moment you were arrested and held to answer without lawful authority, it's all void. It must be removed. Everything. They must restore the liberties that they took from you without lawful authority. That's the first thing. Now the second, now that's federal. That's the federal side. On the state side, yeah, we have the exact same argument, and the state cannot be both accuser and judge in the same cause. Therefore, in all these cases where the state chose to become the victim, right, then the state can also not be the judge, because no man can be judge of his own cause. So we have an opportunity to reconcile a massive number of judgments, both going to the past and to the present. We can't necessarily say anything in the future, because ex post facto could apply. If the government decides that they're going to amend the law today to, to cut this little loophole out and say, oh well, that doesn't affect everything up until this point. Ex post facto is not retroactive. You cannot create a law today that's going to impact decisions from yesterday, right? Laws cannot act retroactively. So if the actions of the court are all unconstitutional and void because the court didn't have authority to do it, then that would mean that all the way up until now would be a massive reconciliation. And it doesn't matter what they do, how they amend the laws, what loopholes they try to plug up or block that will change the validity or the invalidity of the judgments from the past, because that would be ex post facto. Remember, the maximum law there is that any act unlawful at the beginning cannot become lawful over time or by subsequent legislation. Subsequent legislation would be the ex post facto, and it doesn't matter how long it's been. Length of time does not validate an unconstitutional act. That's because fraud vitiates any action of any court. You can always challenge fraud. Fraud is the introduction of an unlawful act by government. Fraud vitiates any action. So when fraud is introduced into the case, that fraud vitiates the action, and it doesn't matter if it's been 20 years. Right? You might have served 5 years, got out, it's been 20 years, and you're going, you know what? I mean, I'd love to have all this go away. I'd love to have my freedom back. I'd love to have my rights to bear arms and all these other things back. But, but how is that going to work? Well, time doesn't validate the judgment because fraud vitiates any action. So any act unconstitutional at the beginning cannot become constitutional over time or by subsequent legislation. So it doesn't matter how long it's been, right? It doesn't matter what they did to you. It doesn't matter how they change it tomorrow. It's going to change the fact that today what they've done is unconstitutional for all of these reasons noted, right? From the founders' own words, from the conflict of interest, from the maximum law to the enumerated obligations codified in the Constitution, to federal statute requiring the automatic recusal of the judicial officers, to where you want to go with this. So the only things that are not in our favor right now is one Supreme Court ruling, Hurtado versus California, 1884, and the states saying we don't have to follow the Constitution. Those are the two issues. So the question to the Supreme Court is, can a state be both accuser and judge in the same cause? But the subsequent questions to that is, can a state, does the judicial branch have the constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution of the United States of America? So again, does the judicial branch have the constituted authority to be able to alter, amend, or destroy any of the provisions or guarantees of the Constitution? The answer would be no, because Article 5 says the way that you change the Constitution, and that must be done by an authentic and explicit act of the people, it is not done through the judiciary. The judiciary cannot legislate. Therefore, their rulings must be consistent with the positive law, right? Because judges are tethered to positive law. They can't legislate. They cannot create law. They have no power to create law, amend law. They have no power to do that. That is a separation of powers issue. So the issue first is, does the judicial branch have the authority to legislate? No, they don't. That's issue number one. Issue number two is, do states have the right to enact their own alternative legislation, substitute it for the guarantees of the Constitution, and then go out and enforce that in violation of the Constitution of the United States? And the answer is also no. Because the 14th Amendment says no state shall create or enforce any law which shall abridge the privileges and immunities of United States citizens. The privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights, the first 10 amendments. They cannot be impaired. This is affirmed by the United States Supreme Court, 2019, Timms versus Indiana, unanimous decision. 6 of the same justices that we're dealing with today said that the privileges and immunities of United States citizens are at a minimum those enumerated within the Bill of Rights, given their legal effect against interference by the states because of their codification in the Constitution's text. So in other words, if it is codified in the Constitution's text, if it's enumerated, if it's written, then that is at a minimum what every single United States citizen is entitled to, regardless of where they choose to reside within the jurisdiction of the United States. Every single person. Therefore, no state can create or enforce any law which shall abridge the privileges and immunities of United States citizens. They can't do it. You cannot create or enforce any law which will interfere with the enumerated rights within the first 10 amendments. That is affirmed by United States Supreme Court unanimous decision, Timms versus Indiana, 2019. That is the standing precedent if we're relying upon judge-made rulings. So the two issues, right, that they're bringing up, Supreme Court created a ruling in 1884 that says that California, you don't have to do what the Constitution says you have to do. Okay. Does the judicial branch have the authority to amend the Constitution? The answer is no. No, they don't, because judges cannot legislate. That's why Clause 1, Article 1 of the Constitution says all legislative power is vested in Congress of the United States. No legislative power is vested in the judicial branch. None. So, no, judges cannot amend the Constitution. Supreme Court cannot amend the Constitution, because the way that they would deem a law unconstitutional is by the Constitution. So they can't deem the Constitution unconstitutional, because the basis of the comparison for the judiciary is the Constitution. To what are they comparing it to absent the Constitution? The judiciary has no right, no authority, no constituted power to amend the Constitution, because they cannot legislate. Second issue is, do states have the right to be able to create their own law, substitute it for the guarantees of the Constitution, and go out and enforce it? And the answer is no. They don't either. And this is also codified in law. Constitutional law, subsection 171 says that state courts and federal courts are equally obligated to guard and enforce every right secured by the Constitution. State courts and federal courts are equally obligated to guard and enforce every right secured by the Constitution. So yeah, state courts are equally obligated. And again, that goes back to the Supremacy Clause, where it says that the judges in every state shall be bound thereby anything in the Constitution or laws of any state contrary notwithstanding. Remember, Article 3 again says the judges both of the United States and of the several states shall maintain their office while in good behavior. The Constitution has presumed the existence of United States judges and state judges. If the founders were referring to United States judges in the Supremacy Clause, then they would have said the judges of the United States shall be bound thereby anything in the Constitution. That's not what they said. They said the judges in every state, and they were referring to state judges. Therefore, the state judges are equally obligated to guard and enforce every right secured by the Constitution. Constitutional Law 171. All right? Okay, so that's about it. We had a good week, I think, this week. We didn't get a ton of stuff done. We're still kind of gearing up, but I think we got two services done. One of which was the state of Virginia. We served a joint session of the Senate and House of Delegates, so we have served the state of Virginia. We also did a service in North Carolina in Beaufort County. I don't know. Anyway, so Washington is the city, but it was Beaufort County. So we did one service in North Carolina. We tried to get out and do some stuff today, but we've been here in D.C. Trying to meet with some lawmakers. You know, our thought right now is that we've spent about a year now going around the country and doing a lot of these services. We've done 108 of them in total, you know, to the city councils and county commissioners, and we kind of need a gut check right now. We need to kind of see, you know, how effective has that been. And so, you know, we met with a couple judges down in Alabama, I think about a week and a half ago, and they were actually the ones that said, you know what, I think you guys are ready. Like you guys have practiced this enough. You guys are ready. Your argument is sound. You're going to win ultimately. I mean, these judges were serious about that, and they were actually the ones that said, you know what, it's probably time for you guys to go to D.C. and talk with some of these lawmakers, because they know what we're doing. Every single one of these politicians know what we're doing. They know who we are. They absolutely know who we are. And so at the end of the day, you know, we needed to come to D.C., and we actually need to spend a little bit of time here meeting with people and kind of getting a gut check on how effective all of this noise that we're making out at the edge is, and really what we're trying to find out is, so there's lots of people that are mimicking Jessica and I. We will never contact you asking you for money. That is a scammer, and they're stealing from people. We will never ask for money for fees or consults ever, guys. Not one of us, not neither Jessica nor I. Those are thieves. Please don't get anything stolen. I'll come back to that in just one moment here. But what we need to do is we need to figure out, are we ready? Is it time to resubmit to Supreme Court? Because you guys know that I did submit to the United States Supreme Court on September 29th, 2023, right, with the original writ of habeas corpus back then. The problem was that the court refused to docket it. The clerk of court, Harris, refused to docket it. And what happened there was that I stepped back and I'm like, okay, the analogy that I was using was, if I choose to play with a scorpion and that scorpion stings me, I can't blame the scorpion for stinging me. I knew it was a scorpion, right? If I'm going to play with a scorpion and it stings me, I can't blame it. The same thing can be said here. I know that these people are criminals. So if I ask a criminal to stop committing crimes, then I can't blame them for what they do. I already know what they are. I'm not going to play with them. And so that's why, back in 2023, when Harris, the clerk of court, refused to docket it, because it's a big deal, right? I realized back then that, ultimately the decision is going to come from the court, but the battle is fought in the opinion of the public. So after I submitted on September 29th of 2023, that's when I started touring the country. So when all this started happening, I started going back and forth across this country. We've been back and forth 32 times over the last 2.5 years, raising awareness on this issue, because that's the only way that we're going to bring this into fruition in order to make it right to be heard by the Supreme Court. The only way that I can do this is by actually getting out there, meeting with people, having rallies, whatever I can, anything that I can do to raise awareness on this issue, so that the court no longer is able to ignore it and has to address this, right? So that's why we started. That's why I started touring the country, going back and forth across the country, raising awareness on this issue, because I knew that was the only way that we were going to be able to get this heard, right? And it takes a lot of work. It sucks. This is a lot of work, and it really sucks to be on the road. It sucks to not have a house. It sucks to not have a place to go to or an address, or it sucks to to be very, very limited in the resources that we have. But this is what has to be done. This is the only way that we're going to get this case heard, is by going out and spending the time and exhausting, our efforts in a worthy cause here. And I know that we're right. Everybody knows we're right. But the point is that I needed to go out and I needed to raise awareness on this issue. And I was not going to resubmit to this United States Supreme Court until I knew that we were ready to go. Right? I knew that we were ready to go, because we don't want to go early. Because if we go early, then we've just shot ourselves in the foot. We just lost our chance, and we're not going to go anywhere. So I knew that we had to gauge this at the right time. So I'm at the point now where I'm ready to get a gut check on this. We're ready to figure out, is it time to resubmit to the Supreme Court? And if it is, then great, we'll resubmit. But if it's not, then we're prepared to go back out and continue to raise awareness, because we know it's the right thing to do. We know it's going to work. No one would be out doing the things I'm doing if they didn't believe in it. I believe in it. I know it's going to work. And someone brought up an issue today. They're like, yeah, but this is never going to happen without violence, right? And I disagree with that. I disagree with that completely, wholly, fundamentally. And you guys, you may think I'm a fool for it. But the thing about a peacemaker is capable of great violence, great destruction, because you can't be a peacemaker unless you're capable of great destruction, because a peacemaker is one who chooses peace. I know I could destroy this system. I know the knowledge that I have, the evidence that I have. I know that I could destroy this whole system. We could tear the whole thing down from the top to the bottom. We could hold all these people. I know that we're capable of great violence, but we're choosing peace. We're choosing it, right? We're restraining ourselves from the exercise of that for one particular big reason. And that is that the definition of a patriot is one who loves and defends his country. That's the definition of a patriot. So if you love something, then destruction would never be an optional outcome for that you love. I love this country. I will defend this country. I have my entire life, and I will continue to defend it until the day that God calls me home, because I love it that much. But if you love something, then destruction can never be an optional outcome for that's loved. So I won't seek destruction, right? Because if I seek destruction, then we're destroying that we love. So I'm choosing peace. I'm choosing to restrain. I'm choosing to not exercise the destructive power that I know that I have, because I'm trying to protect this country and not destroy it. So patriotism then is not a call to arms, you guys. It's not let's go out and get our pew-pews and let's go and, and unalive our brothers and sisters. That is not patriotism, because that leads to destruction, right? Patriotism is a dialogue between your fellow man and the larger world as a whole about not only what is good about your country, but how it can be better. You see, patriotism is rooted in humanity, and it brings peace and respect, right, and love. Nationalism is when you focus on the good of the country, but you don't acknowledge that there is also bad. Therefore, you can't resolve it. Nationalism leads to war and conflict, right? And violence. We don't want to go that direction. We want to go the peaceful direction because we're patriots and because we love this country and we want to see this country continue to exist. And that's why I'm going to remain a peacemaker until the day that I'm proven a fool or God calls me home. Because I don't want to head down the destructive path. And I don't think that we're going to have to. Now, I understand that I'm just one person within this large body here. And destruction could potentially be the outcome that we're faced with. Even Abraham Lincoln said that if destruction be our fate, then we ourselves must be the author of it, right? But I myself am not going to head down that path, because I believe that we can do this in a peaceful, non-destructive manner. I do. I really do. And again, I might be a fool for believing it. You guys might think I'm a fool, but that's the path that I'm on. And that's the path I'm going to continue on until I'm proven a fool. All right? Because if you love something, the destruction will never be an optional outcome for that's loved. So what I fight for, the only thing I'm fighting for, is the Constitution of the United States of America, because that's the only thing that makes what I love exist. Nothing else makes America America but that Constitution. So if we can't believe in it, if we can't fight with it and for it and the preservation of it, then we have lost that which we love. Therefore, nothing else is as important as the preservation of the Constitution for the United States of America. And that's why, when I see these services, these videos that Jessica's making, she's doing an amazing job on the video front, guys. I mean, she's making some incredible videos. But when I see the reactions of these public officials, these city council and county commissioners, and when I see the looks on their faces and their attitudes with regard to the things that we're saying, guys, I'm telling you, it pisses me off. It makes me fucking furious, because they're laughing, right? Because they're saying, oh, well, the state does something different, so that's okay. And there's nothing more un-American than not acknowledging the Constitution of the United States of America, right? We have all of these public officials that is literally smiling at us, laughing at us, telling us, oh, well, the state does something different, so that's okay. And there is nothing more anti-American than that, right? Nothing. The only thing that makes America America, what created America, is that Constitution. The United States of America, the Union, was created by that Constitution. So there's nothing more unconstitutional than refusing to recognize it and acknowledge it. That's why we have to do this. That's why I'm so passionate about this, is because that is the only thing that makes America. There's nothing else to preserve. We lose our union if we lose the Constitution. And those public officials are laughing at us, right? And I get that they're laughing at us, and it pisses me off, right? And I don't know the ultimate outcome of this of what God's got us doing here. But I don't think that God's going to lead us down the path of destruction. Somehow we're going to finish this. I believe quite strongly that we're going to find honor within this institution, and I think we're very, very close to it. You know, there's things that you guys don't see that and don't know about that we see, Jessica and I, right? We're out here every single day traveling the country. Yes, we've done lots of these services, and yes, it appears as though nothing's going on. But yes, just last week we met with a couple judges in Alabama who said, we're right, we're going to win, right? That were giving us advice on this and said, yes, everything you're doing is absolutely spot on, true, and accurate. We have a state legislator in New Hampshire that's about to propose an amendment to the Constitution of the state of New Hampshire to comply with the Bill of Rights, every bit of it. You can't not do this, right? We have a lawmaker that believes in this and is going to do that. We have another state representative who is out serving the notices that we're serving right now as we speak, right? He's going to counties within his state and is serving as a state representative, right? The notice that we ourselves are doing, that shows that this is working. You know, we have Homeland Security that detains Jessica and, you know, interviews her and questions her for 2 hours, ultimately to release her. But in that question, that Homeland Security officer says, man, you're really pissing off a lot of high up people with what you guys are doing. Good. I'm glad. You know, we're walking into these county commission meetings and they already know who we are. They have pictures of us. Their security is given pictures of us. We had one police officer in one of these counties that came up to us and showed us a picture of us on his phone, right? As we're walking in, he's like, "You're these guys, aren't you?" Well, he wanted to support us because he likes what we're saying, likes what we're doing. But nonetheless, he was given our picture ahead of time to say, "Watch out for these people." It's working. We've had sheriffs take their badges off and give them to me. Say, you're doing the right thing. You're doing the right thing. You're right, right? That's supporting us. We've had dinners with governors. We've had dinners with senators, congressmen that all say we're right. You know, we've had a couple county commissioners in West Virginia and Michigan ask us to please come to their county and serve their county commission so that they can have what they need to actually be able to try to fix this problem. Asked us to come to their county commission, serve them with the notice so that they can take that and try to fix their local government, because they don't see the ability to do it until they get a notice from us, right? That's winning. That's getting around. That's getting their attention. This is the stuff that is actually happening. You guys can't see this, but we can. So, you know, this may not work. You're right. It may not work, but I believe that we're going to find honor somewhere in this government. And I believe that we're going to find honor somewhere within the Supreme Court of the United States. I believe that that's where we're going to get it. I believe that one of these justices is going to step up in honor and agree to do something about this, because they have the power to do that. They have the power. They control every single judge across the entire nation. One United States Supreme Court justice could prepare a judicial edict that would apply to every single judge across the country and require them to comply with the limitations of power that the Constitution provides. We could get that. Now, I don't know which one it will be, but I believe that that's where God has taken us here. We only need one. We only need one. Because one Supreme Court justice can sign a writ of habeas corpus. Remember, we're going there under habeas because we're invoking not the appellate jurisdiction, but the original jurisdiction. We're not going there certiorari. We're going there with a judicial relief. And judicial relief only requires one United States Supreme Court justice to sign it. So when we come in and invoke original jurisdiction, if we know that we have one Supreme Court justice willing to sign it, then that means it's time to go. It's time for us to resubmit. We got one, right? But we don't want to go early, which is why coming here to Washington, D.C. right now is so important, because we need to get a gut check. on where we're actually at. How effective has been this last year that Jessica and I have been going back and forth across this country, serving, these 108 city councils, county commissioners? How effective has that been? And if it's determined that it's been effective, right, and we get good feedback from these legislators here and whoever else, lobbyists, whoever we meet, if we get good feedback from them, then that might mean that, yeah, it's time. Resubmit, because we got a justice that's going to get behind this. If we don't get good feedback, then that just means it's not time yet. So a lot of you are saying, well, hurry up and get this done and, whatever. Guys, I don't control the second half of this. The only thing I control is myself and what I do. And all that I can do is continue to move forward under my faith that this is going to work. Continue to put pressure by taking one step every single day to bring about that change, right? To bring this into fruition. That's the only power that I personally have. And every single day, that's the power that I exercise. I will get out there and I will continue to push forward until such time as I'm proven a fool, we win, or God calls me home, right? So, but I don't control the other half. I don't control the other half. So when you say to me, buck up and start, quit dragging your feet and get this done already. Well, I don't control that, right? I don't control the outcome. I don't control the timing. We're going to get this done. But before we can get this done, we have to make sure that it's ready to go, because we're not going to go early on this. We're not going to lose our opportunity to be able to address this by having the court just simply ignore it again, right? That's why, 2 years ago, after the first time I submitted and the court and the clerk of court simply said, oh, we're going to ignore it, we're not going to docket this, right? I said, I'm not going to do it again, right? Because had he docketed it back then, we would have shot ourselves in the foot, because it wasn't right to be heard. None of you knew about this, because on September 29th, I hadn't spread it around the country. So it wasn't the right time to go. That was God saying, no, it's not. And so what I had to do is I had to start traveling the country, raise awareness on this issue, bringing it to your attention so that all of you can understand the elements of this argument, so that we can ultimately make the court stop ignoring it and actually address this issue, right? And then when they address the issue, we will get the outcome that we want. But I don't control that. All that I control is what is the power that I have. And the power that I have is I continue to push forward until I know that the time is right and that we're going to prevail. We don't want to go early. So that's my point here, is that you guys might not like the timing. You guys might say, well, he should have been done with this years ago. At the end of the day, you guys, you're more than welcome to come and do this for me, because this life sucks, right? It's not easy. I don't get paid. I've got multiple master's degrees. I could be out making millions of dollars and living a normal life and having a house and a car and a white picket fence and a dog and, being comfortable. But that's not what God has led me to do here, because I believe in something. I know it's wrong. I know it has to get fixed. And I know that God's asked me to do that. So, this is not an easy life. And so those people that want to, speak negatively about me or what I'm doing, that's one of the reasons why I just simply block you, because I don't have time for anyone's negativity, right? I'm out here and I'm doing this and I'm fighting for everybody. And if you don't like what I'm doing to help you, then, or you want to say something negative, I only have so much energy, and I'm not going to allow any of that negative energy to even mess with me. Right? It's hard enough for me to stay positive every single day, facing these people that are laughing at what we're doing, even though I know that every single time they laugh, they have just placed that noose around their neck. I know that, right? You all know that. And so as we go out here and we bring this to the attention of these public officials, when these public officials fail to take action as lawfully required, right, as lawfully obligated to report the crime and address the crime and to prevent the continued criminal conspiracy from continuing, from proliferating, then they themselves are becoming complicit in the crimes. They then become opposing party. And that's also one of the reasons why I don't continue to talk with them, right? Once we provide the notice to these public officials, I don't return to them, Because if I did, they're opposing party, and now if I return, that would be witness tampering, could be intimidation, depending on that. So they get one chance. They get to decide how they want to act. If they choose to continue to act criminally, that's on them. We have it on the record. Okay. So so there's still a lot of scammers out there. Guys, if you guys want to donate, I would recommend go to the website www.justicewithoutlimits.org. There /donate, and you can find the donation points from there. That's the safest way to do it. So www.justicewithoutlimits.org /donate, and you can donate from there directly on the website. If anyone messages you, texts you, asking for you to come to or asking you to donate money so that they can come and help you with your case, or have you received the affidavit yet? And that's not coming from Jessica and I. There are scammers that use our pictures, that use our logos, that are pretending to be us, that are very smart, that are tracking us and following us and is aware of the things that we're doing, and they're pretty good at it. But they're telling you to donate to places other than Cash App, Chime, Venmo, PayPal. We shall be free. WESHALLBEFREE, spelled properly, right? That's the only way that we can receive anything. We don't receive Apple Pay or gift certificates. We will never message you asking for money. We aren't solicitors. We are operating on a donation-only basis, and that's up to you. You want to donate, you like the service we're providing, you want to continue to see us do it, then you guys are donating. So please do not donate to scammers. They've gotten enough money. If you have donated or if you have been scammed, I'd ask you to please reach out to your local Attorney General, Office of Consumer Protections, report the crime that was committed, because we do really want to get these people arrested. I mean, we want them to get caught because they're stealing from all of you in our name, and that is a absolutely disgusting thing to do. So please don't donate. All right. Thank you so much, my friend over here. I see you're offering to donate. I appreciate that so much, guys. The reason why I operate on donations is because, again, I spent half of my life up until about age 36 using all my talent to benefit myself. Again, I've got 3 master's degrees and graduated with high honors. Before all this, I was making a lot of money, over $800,000 a year. I owned my own security engineering firm, and that's what I did. I made a lot of money, and I certainly benefited from my abilities. But in the blink of an eye and the swipe of a pen, it was all taken from me through a divorce, through the injustice of this system. And so the problem was that back then, the measure of my being a man was based upon the things I had. The more I had, the more valuable I felt. So my measure of being a man was based upon the things I had. And that's a terrible, terrible place for a man to be. I don't ever want to be in that place ever again. So instead of being in that place, I figured that this second half of my life here, I'm going to, one second. This second half of my life here, I'm going to use my talents to benefit others and see if we can create something that will last. And that's what we're trying to do. I see that this one's about to die too. I'm going to have to drop off because all these phones are all dying now. But rather than working for money, I don't want to work for money anymore, because working for money was not a good place to be. So instead of working for money and having that be the reason why I'm doing the things I'm doing, I'm now providing the best service that I can provide. I'm doing the best that I can do, and I just know that if I provide the best service possible, that you guys are going to make sure that I have the resources that I need, and that way I can focus on the service as opposed to the money. So instead of waking up every day and having an obligation to do certain things and be limited in my ability to do what I know God needs me to do to be successful, I don't accept any contracts, nor does Jessica. We are not going to be obligated to do anything in particular because we never know what God needs us to do. So if we are doing things for the money, right, then we're not able to serve God on a day-to-day basis, and that's what we're here to do. All right, that's absolutely what we're here to do. So we will only operate on donation and donation only. We will not operate under contract because we're not going to limit our ability to wake up and do what God needs us to do. That's where our contract exists. That's where our obligations exist. And so we serve him, and that's why we're being successful in the work that we're doing. Right, guys? So please continue to like, follow, and share our videos. That keeps them going out in the algorithm. You guys have done really awesome over here on Facebook. We've had just phenomenal video views. Thank you, Jessica, for the awesome videos. TikTok, you guys need to pick it up. I used to do so good with TikTok and used to get a lot of views, but that's really petered out. And I think I just went over 50,000 followers on Facebook. Or I'm almost over 50,000. That's pretty awesome. I don't know why I'm so slow and Jessica's so fast, because she was far less than me, but now she's over 70,000 and getting 1,000 a day, which awesome, I guess. But please continue to like, follow, and share the videos. That keeps us out in the algorithm. Reposting them is probably the most important thing to get them out in the algorithm. I don't have a whole lot going on here at YouTube. I hope that we can get a whole lot more views there. And then I'm trying my best to pick up over here with Instagram. I know that you guys are kind of a sleeping giant, and I hope that we'll get a whole lot more viewers. But we have a pretty small following base there. So I ask you guys to please continue to like, follow, share. Please donate if you can. Keep us out on the road. And thank you guys so much for everything you've done, for being with us on this journey. It's been amazing. And I hope we get good feedback this week here in Washington, D.C. So if we do, then we're ready to resubmit. Already. If we don't, then we'll see you back out there on the road. All right. We're not going to quit until this is done. God bless you guys. Thank you so much. Have a great night. This is Jessica. Thank you guys so much for being with me. God bless. Have a good night. TikTok, thank you guys so much. God bless, guys. Okay. This is Facebook. Thank you guys so much. Good turnout. Really appreciate you guys. Yeah, so we do have a Rumble channel, and but I haven't done much with it. I need to do a lot more with X. So that's one thing that Jessica and I have been talking about is how do we pick up on X and get a lot more views. We do have a Rumble channel, but we haven't done a whole lot there. So hopefully we'll get both those picking up. But yeah, I appreciate the advice there. All right. God bless, guys. Have a good night, okay? Thank you. Thank you, YouTube. Appreciate it so much. God bless, guys.